Welcome to PrivacyCast, a podcast dedicated to share knowledge about privacy in India as well as across regions. Today we have none other than Elze Hart. Folks, my name is Akarsh Singh. I'm the host of the podcast. I'm one of the co-founders at Tsaaro, also a chief privacy officer at Tsaaro Consulting. We have today none other than Elze Hart. She's a partner at Dentons Legal based out of Netherlands, a specialized lawyer in data and technology. Her expertise lies in AI governance, data protection, GDPR, as well as the privacy laws across the world. So, welcome, Elze, to PrivacyCast. And we look forward today to discussing with you GDPR versus the India's DPDP Act. What are the scope and applicability discussions? How should people look at it in both the countries, in India as well as when we look at Europe? How is the data transfer going to harmonize? We are going to cover all of that today. So, looking forward to Elze. So, Elze, while we get on the conversation, how do you see the applicability of the Indian privacy law to European businesses?
Thank you. Thank you so much, Akash, for inviting me to be here. I love to speak about the Indian DPDPA and the differences between the DPDPA and the GDPR. First of all, I was just, oh, there is a Privacy Act in India. Great. Good for you. That's it. But then I started to reading it and I was like, whoa, has a lot of implications for European businesses as well, because it also, it also applies to lots of them, because if you're offering goods and services in India to Indian people, it applies to you. And there are a lot of Indians and many European companies.
1.4 billion of us, not less than.
Exactly. And companies want to be in India. So
Yeah, and
it also applies to European companies that are established in Europe and just offer their goods and services via the internet to Indian people. So it's relevant to them and
and
therefore
also
also
when you
relevant for me.
also
Yeah.
like from a customer perspective, when you talk about applicability, so definitely if somebody is targeting an Indian customer, the law applies. What's your take on the employees? Because a lot of European companies are opening up GCCs in India and getting their IT work, done in India, right? Specifically, if you see, what's your thought on that? Like, what is it going to change? Is it going to become easier? Elsa?
Yes, I think a lot will change. First of all, most companies really like to have a GCC in India. It's easier, it's cheaper. A lot of reasons. And at this point, you have, in order for a European company to transfer data to India, you have to have adequate standards in place, like model contracts, SECs, like we call them, because the European Commission does not have an adequacy decision in place, which makes it easy to transfer data to India. So this means you have to conclude those contracts and do a transfer impact assessment to see if you really can safeguard the privacy of the individual. At this moment, it's still a risk when you transfer data to India. I think with DPDPA, the standard of data protection will increase in India, which will make it easier to transfer data to India under the SECs. So I think this is good news for European companies. And
And it's a
maybe
and it's
in the
a good news
future,
for Indians, right?
yes, yes,
We
yes,
have
for sure.
1.4 billion of us have more privacy.
Wow.
So yeah, it matters a lot. Think about the size and number of customers that organizations are facing. And so moving on, right? Talking a bit more about. So I think what we talked about is indirectly, I think we talked a bit about cross-border transfers. And in cross-border transfers, you also explained that we have to do transfer impact assessments. And while organizations will now transfer data to India, once the law gets live, the risk will be lesser, so more data can be transferred easily, right? If I'm trying to summarize the conversation till now, moving on from cross-border thought process, how do you see in terms of like businesses with heavy data processing, right? Like, and definitely we talk when we started, we talked about businesses which are in Europe and trying to sell in India, right? They're already selling in India, right? If you look at biggest organizations of Europe are the biggest brands in India, right? And they are selling uh, like everything, internet services, booking services, you name them, right? And they are there in India. So how do you see what's going to change for them, Elsa?
Well, what I find interesting, but I would love to hear your views on that, is the at this moment we see a lot of companies they comply with the GDPR, and if you comply with the GDPR, you comply with most laws in the world because GDPR is usually the strictest. Exceptions there, but usually. So now with the Indian privacy laws, we see something different, and that's the legal ground on basis of which you can process data. So from a European perspective, you usually have a legitimate interest. Well, often you have a legitimate interest to process data. Because if it can be necessary for your business operations to process data, or even direct marketing can be a legitimate interest. But in India, under the DPDPA, you don't have legitimate interest, and that what struck me, that there is a huge consent framework under the Indian DPDPA,
Yeah.
which could also imply that a lot of European companies should obtain consent, and we don't like consent usually. So maybe you can explain a bit more about what you need to do as a European company.
So what has happened in the lawful basis differentiation? So if you look at GDPR, the lawful bases are divided in two parts, right? Personal data and sensitive personal data. And
Yeah.
in there we have, I think, what, six options and then 10 options, right? If you read it carefully. In India, what has happened, we have two options, right? Either we take consent, and we don't have a differentiation between a PII and SPII. So that's another challenge. So we just have two options. If you want to take data from someone, it's either a consent or it's a blanket legitimate interest. Under a blanket legitimate interest, employment gets covered, health issues can get covered, like urgent data that is needed gets covered, and a lot of other things are getting covered. So when you say consent, and what is going to change for European businesses, so I think while we do records of processing activities, I think the template thought process where there are more options to choose, one of the things is going to change, right, for Indian personal data. So it cannot be the same risk formatting, it cannot be the same way of risk mitigation. It's a bit different, right? It's like you go to the gym, like you are GDPR compliant, so you go to the gym and you are fit, you are GDPR compliant, but now you have to go running, right? So when you have to go running, you definitely fit, you can run easily, but the format changes, right? If you look at any other law, the format of fitness changes. So again, a fitness for running is different, and fitness just for gym is different. So that's the one difference that I would also give an analogy around that. So consent, yes. So European businesses in India, we are expecting the rules to go live in another by end of this month, and then we will get 2 years or 18 months to 2 years to comply fully to the Indian privacy law. And in that between that time, I think the consent becomes really really heavy. So what you are going to do is, just take consent and be specific on purpose. If you have taken data on or processing data on any other basis for a B2C customer specifically, I think that's not going to work in India, right? That's going to change a lot, especially in B2C. In B2B, still there can be an employment contract or something like that, but B2C, I think it's India is like consent. There's no option.
I think that's very relevant for especially for European companies, that they should not only consider to update their transfer data transfer assessments, but also they should check whether their legal basis for processing data is still
Exactly.
compliant and works. There's some
Yeah.
work to do, but we have 2 years, right?
Yeah, we have 2 years.
That's
So
good.
we have good time. We should have. It's not out yet, but that's the thought process. So I was part of one of the ministry consultations, right? So the consultation is going on where people are discussing, what can go wrong, or if somebody needs an exemption. So that conversation is going on. We are also forming the data protection board in India, right? So just like a supervisory authority, we have a data protection board. So that board is getting transformed, right? So in this budget session of India, the financial budget, around how should I call it? Around $500,000, right? Uh,
Yeah.
I would rather say it's around $700,000 were allocated to the data protection board this year to run and function. So, and over the period of time, they are going to increase that budget for the data protection board. So that's where we are headed. Moving on, what challenges? So, Elsa, we talked about consent, right? We also talked about the transfer impact assessment, right? Uh, what more challenges do you think that current European businesses are facing in terms of data transfer to India? And what future issues that you think can arise that we can talk about and people can, take a course change from here?
Well, I think there are more compliance issues, especially the amount of work that needs to be done, and the amount of laws that need to be complied with in general. But also, I think things like purpose limitation are very important to companies. Other challenges are data retention. How do we ensure the data is not retained too long and destroyed in the right way? Other challenges remain security, cybersecurity, especially. How do we ensure that everything is secure? And this is a trend. It's not only relevant for India. It's relevant globally, actually. Um, so I think these are the main points. Yeah, I'm not sure if you have something to add from the DPDPA perspective.
I feel like the difference, if I just think simply about difference between laws, right? I feel the human rights are also a bit lesser the numbers are a bit lesser here. Like we do not have a portability thought process. Like, the right to portability, it's not
Yeah.
there with us. But there are new type of rights with us, like right to nominate. So if somebody who's not able to use a phone, like when I say use a phone, it actually means that somebody is on bed, right? As simple as that. Somebody's not able to do
Mhm.
anything online, so then they can take someone's help to do these things, right? So that's a right to
Okay.
nominate is also a big thing in India that will come up.
Okay, that's
Yeah.
relevant. Yes. So
Yeah.
this is something we should take into account. Yes.
Yeah, and the second thing that is a huge difference in both the laws, is about consent managers. So we do not have clarity on consent managers, but that is also something that we should expect, where, a lot of chaos is going to happen because
Yes,
consent
because
man.
what
Yeah.
is a consent manager? From I was reading about consent manager. Is it like a management system? Is it a person? Is it what is it? Can you and how do we comply with this obligation?
So consent manager is a technology solution. It's not a
Mm-hmm.
person. So basically, the thought process is that a consent manager will sit between a data subject as well as a data fiduciary, right? So
Mm-hmm.
that so a data subject can, just like a Google authentication, Google Auth, right, where we do sign in, right, from Microsoft or Google to different organizations through tokenization.
Mm-hmm.
Similarly, a consent manager is thought to be sit in between the fiduciary as well as the data subject. So data subject can quickly see by using a consent manager as to where all he has given consent. So it's a
Okay.
smart thought process. The only challenge that we are looking forward to is implementation, right? Whether we can actually implement this, right, or not.
Yes, I mean, here in Europe, we are working on cookie bars forever to make sure that we obtain all the right consents and that it's distributed to the right persons. it's still a mess, so to say, and
Yeah.
it's really hard to implement. If you need to obtain consent for so many purposes and you have to have a manager in place, this will be very hard to ensure. Yeah.
Yeah, it's something that is of concern in India, and everybody is challenged. Not especially Indian organizations, right? We have 1.4 billion people in India, right? And if you actually see, uh, I was reading a stat that around 60 million people, 600 million people, sorry, have a mobile phone, right? So
Yeah.
when 600 million people have a mobile phone, then we have a lot of data that is running in India, right? So there are so many data subject rights that are going to fall and come and through. So we look forward to this. And Elsa, also we've come to the end of the session today. So thank you for joining us. Thank you for coming to Privacy Cast, and thank you for sharing your views and educating us on the differences between the GDPR as well as the Indian DPDPA. And
Thank you so
thank you.
much. Thank you. Thank you. It was wonderful to be here.